everyone, welcome to today's video where we delve into the fascinating world of comparative law. Our main focus today will be Suriname, a country located in South America, and how it compares to Indonesia, a nation located in Southeast Asia. Both countries share a common thread in their legal heritage, a legacy from the Dutch colonial rule. Let's dive in. The Republic of Suriname is located in the northern coast of South America, bordered by Guyana to the west, French Guyana to the east, Brazil to the south, and the Atlantic Ocean to the north. The country is geographically divided into a cultivated northern coastal plain, home to most of its population, and an inhabited southern rainforest and savanna, which covers about 80% of the Suriname's land surface. The western coast of Guyana, of which Suriname is part, was discovered in the late 15th century. The original inhabitants were Amerindians, who are now called the indigenous people. After different failed attempts of colonization by the English and the French, Suriname was captured by the Dutch in 1667. Suriname then became part of the Kingdom of Netherlands and was administered by a governor appointed by and representing the Dutch crown, with the cabinet appointed by the governor and also an elected parliament. Since the founding of Suriname in 1667 as a Dutch colony, Suriname was exploited primarily for the production of sugar and coffee, and therefore Suriname's economic history is that of a plantation economy that continued to operate until the mid-20th century. The colony's plantation economy was based on cheap labor using slaves from Africa. After slavery was abolished in 1863, indentured laborers were recruited from India, China, and Indonesia. The descendants of these immigrants now form the larger part of the population of Suriname. Despite efforts to preserve plantation production, Suriname's economy as an agricultural supplier declined. In 1916, the Aluminum Company of America began mining the country's newly discovered reserve of bauxite, the principal ore of aluminum. Later, especially after the Second World War, the Dutch interest in Suriname revived, noted by the arrival of the Dutch Mining Company in 1939. The Netherlands began to provide development aid to Suriname in 1948, and in the year in which the Suriname's political autonomy began. In 1954, Suriname acquired autonomy from the Kingdom of the Netherlands, and on 25 November 1975, it gained independence in a peaceful manner. The governments before and after independence were consist of different political parties organized in a large part on an ethnic basis. In the early years of independence, Suriname adopted a parliamentary democracy where parliament played an important role in the government. 5 years later, the civilian government was replaced by a military regime that soon declared Suriname a socialist republic. On 25 February 1980, a military coup d'etat took place which removed the legitimately elected civil government. Suriname was governed by a military dictatorship until 25 November 1987. In the 1980s, the lack of respect for the constitutional state, serious violation of human rights, a devastating war in the hinterland of Suriname, and a dramatic economic deterioration were manifest. The process of democratization, which had officially started in January 1988, suffered from the second coup d'etat on 24 December 1990. Since May 1991, Suriname has again been governed by a democratically elected civilian government. Suriname's legal roots trace back to its history as a Dutch colony starting in the 17th century. The Dutch influence shaped the country's governance and legal system, introducing a civil law tradition. In 1869, the civil law framework was formalized with the codification of laws based on the Dutch system. Suriname history reflects the influence of multiple legal traditions, including Roman law, canon law, common law, and Dutch Germanic The civil law tradition introduced during colonial rule was consolidated in 1869 through the codification of a Dutch legislation under the principle of concordance. This legal heritage continued past independence in 1975, allowing Suriname to build a democratic presidential system with a parliamentary supervision. Article 1 of the Suriname Constitution emphasized the country's status as a democratic state founded on the sovereignty of the people and in the guarantee of human rights. The government of Suriname is based on the doctrine of separation of powers. The president is the head of the state, head of the government, chairman of the State Council, and also chairman of the Security Council. He is responsible to the National Assembly. The executive power rests with the President, and together with the Vice President and the Council of Ministers, the President form the government. The political power rests with the people and is exercised in accordance with the Constitution. The political democracy creates the condition for the people's participation in general and free election. The National Assembly represents the people of the Republic of Suriname and expresses the sovereign will of the nation. The National Assembly itself is the highest body of the state and consists of 51 members who are elected per district on the basis of free election. The legislature is jointly exercised by the National Assembly and the government. Suriname's legal system operates under the civil law tradition. This means that the laws are codified under a written statutes, which judges strictly apply when making decisions. Unlike common law system where judicial precedent holds significant weight, Suriname's courts rely on these codified laws. The hierarchy of statutory regulation in Suriname is in the sequence as follows: International Convention, the Constitution of the Republic of Suriname, State Act, Presidential Resolution, State Decrees derived from State Acts, and also Ministerial Decrees derived from State Acts. The Constitution of the Republic of Suriname is the supranational law of the country. It sets out and defines the authority of main bodies of the state. All other legal regulations and laws must be in line with the Constitution, otherwise they will be null and void. Chapter 15 of the Constitution of the Republic of Suriname addresses the legal system of the Suriname. Suriname's law acknowledges two authorities that can administer justice: the Cantonal Court, which is the lower court, and the High Court of Justice, which is the appellate court. Suriname also recognized the original jurisdiction of the Caribbean Court and also the contentious jurisdictions of the Inter-American Court of Human Rights. Article 132 of the Constitution stipulates that civil law, commercial law, military law, penal law, and also procedure law shall be regulated by law in general codes, without prejudice to the power of the legislature to regulate special subjects by a separate laws. These provisions demonstrate one of the features of civil law tradition, which is characterized by a codified legal provision. Article 136 of the Constitution mandates that all court rulings must specify their underlying reason, referencing applicable codified law. This is also reflect the civil law tradition reliance on the written statements. At the apex of the Constitution, which guarantees democracy and human rights, there relies the principle of legality, which is no action is punishable unless a pre-existing written law deems it so. Judicial authority lies within the Court of Justice, comprising judges, the Attorney General, and other judicial staff. This centralized structure ensures consistency across the nation within the Republic of Suriname. Indonesia's legal system also stems from Dutch colonial influence, adopting the civil law tradition. Both countries, Indonesia and Suriname, feature codified legal system, emphasizing written law over judicial precedents. However, their evolution diverges due to cultural and historical factors. For example, both nations uphold the principle of legality. In Indonesia, it is stipulated in Article 1 of the Criminal Code, while Suriname incorporated it in Article 131 of its constitution. This principle ensures that no one can be punished for an act that isn't explicitly prohibited by law. However, customary law plays a different role in each country. Suriname's constitution integrates indigenous customary law, such as the Maroon laws, reflecting its diverse and cultural fabric. Conversely, Indonesia's adat law, recognized under Article 18 of its constitution, supplements national legislation and varies widely across regions. However, a notable difference lies within the treatment of customary law. Suriname integrates customary law, like the Maroons law, into its legal system, reflecting its multicultural society. In Indonesia, customary law, or we can call adat law, is recognized under Article 18 of its constitution but operates more as a complementary system. Indonesia adat law has a flexible application, allowing integration into modern statute when it does not conflict with state law. In contrast, Suriname's approach to customary law showcases an effort to preserve indigenous autonomy while aligning it with constitutional principles. While Indonesia incorporates adat law largely in localized governance, Suriname's integration is more like a symbolic and represents its multicultural legal identity. In practice, Suriname's judiciary focuses on applying codified statutes to resolve disputes. This is a hallmark of a civil law tradition, where the role of judges is to interpret and apply written laws rather than create a new legal precedent. In Suriname, the Constitution, Article 132 and 136, establish a clear framework for judicial decision, emphasizing the application of codified laws in both civil and criminal cases. The legal structure ensures a detailed reasoning in judgment and adherence to written statements. Similarly, in Indonesia, judges adhere to codified laws, while occasionally considering customary practice in specific cases, especially in regions with a strong added tradition. To summarize, both Suriname and Indonesia share a civil law tradition rooted in Dutch colonial rule. While their legal systems have evolved uniquely, the emphasis on codified laws and the principle of legality remains central. Understanding these similarities and differences not only enriches our knowledge of comparative law, but also highlights the importance of legal tradition in shaping national